Good morning, this is your Kelso Report for Thursday, December 27th, and I'm your host, Clark Kelso. Hope everyone had a happy and safe holiday. We begin today with Ninth Circuit decisions involving the EPA's application of the Clean Air Act to exploratory drilling operations in the Arctic Ocean, the preemptive scope of the National Bank Act, and the proper interpretation of the federal mail fraud statute. We then turn to a 4th District ruling about a trial court's ability to reconsider on its own motion the dismissal of a suit on forum nonconvenience grounds. Let's start with the Clean Air Act. Judicial deference to an agency's interpretation of the law and to an agency's exercise of discretionary judgment was on full display in Redoyle v. EPA, where the Ninth Circuit affirmed the EPA's decision to approve, under the Clean Air Act, 2 air permits authorizing exploratory drilling operations in the Arctic Ocean by a drill ship and its associated fleet of support vessels. In approving the permits, the EPA decided that the statutes do not require the support vessels to use the best available control technology to control emissions. Because this interpretation required the EPA to reconcile conflicting positions in the Clean Air Act, and the EPA's interpretation was reasonable, the Ninth Circuit upheld the interpretation under the deferential Chevron standard. The EPA also concluded that the area within a 500-meter radius of the drill ship was exempt from ambient air quality standards. That involved a discretionary decision under the Act. And finding some support for that decision in the record, the Ninth Circuit also deferred to the agency's exercise of its discretionary determination. Next we turn to banking law. The split between federal and state regulation of certain industries is mostly a matter of historical accident. Regulation of banking is a good example. Most bank regulation was done by the states until after the Civil War and the enactment of the National Bank Act. Slowly but steadily, the regulatory balance shifted as banks decided to establish themselves as national instead of state banks. Of course, it permits you to have a national business, which in banking is highly favorable. As a result, we now end up with a large portion of the industry operating under national bank charters and standards. But even under such charters, general provisions of state law govern the operation of national banks, except to the extent that such state laws prevent or significantly interfere with the national bank's exercise of its powers. One of the federal banking regulators, the Office of the Comptroller of the Currency, has determined that a national bank's federal banking powers include the power to set account terms and the power to charge customers non-interest charges and fees. In Gutierrez v. Wells Fargo, the Ninth Circuit reviewed a judgment entered against Wells Fargo in a class action brought under California's unfair competition law, which challenged the bank's practice of posting checks in high to low value order, a practice which maximizes fees from overdraft checks. The issue was whether the order of posting checks was a pricing decision authorized by federal law, noting that the sole reason for using the high-to-low methodology was to maximize its fees from overdraft checks, and that the Office of the Comptroller of the Currency had explicitly declared this posting practice to be a federally authorized pricing decision. The Ninth Circuit held that most of the state law claims against Wells Fargo were preempted, and it vacated the district court's $200 million restitution order and reversed its injunction against the bank. The only claim which survived as a matter of law was for affirmative fraud, a claim based on alleged representations by the bank that it posted checks in the order in which checks were written. The court remanded for consideration of the facts supporting that claim and consideration of what remedy, if any, might be appropriate. Next we turn to the federal mail fraud statute. Mail and wire fraud are some of the most broadly defined federal crimes, and they often sweep in a lot of essentially related criminal activity. If part of the fraud involves use of the mails or the wires, well, you've probably committed a federal crime. But there are limits even to mail fraud, as the Ninth Circuit held in United States v. Phillips, where the defendant embezzled funds from a high-tech startup of which the defendant was the CEO. The defendant then used those funds to make several expensive purchases, all for personal use. Reversing the mail fraud conviction, the Ninth Circuit panel noted that the success of the defendant's fraudulent scheme to obtain funds from his startup did not depend in any way upon the use of the mails. The fact that the defendant subsequently used the money to buy certain items, one of which was mailed to the defendant, was insufficient to support the mail fraud conviction. But don't think this defendant is walking the streets free, since he was also correctly convicted of money laundering, which of course does not require proof of the use of the mails. Next, we turn to forum nonconvenience under state law and civil procedure. The finality of a trial court's decision to deny a motion to dismiss on forum nonconvenience grounds was before the 4th District in Williamson v. Mazda Motor of America. Now, this lawsuit was filed back in 2004, and it arose out of an automobile accident in Utah in which the passenger sitting in the rear middle seat was killed. The plaintiffs, who were Utah residents, claimed that the car was defectively designed because the rear middle seat had only a lap belt and did not have a 3-point lap and shoulder belt. One of the defendants was a California company, and its corporate parent was a Japanese company. The trial court denied the defendant's motion to dismiss on forum nonconvenience grounds based on its conclusion that the trial would most likely be a battle of the experts on seat belt design, and those experts would not be inconvenienced by trial in California, where, as it happened, all of the lawyers also resided. The court later dismissed the entire action on federal preemption grounds, and after several appeals, the United States Supreme Court granted cert in the case in 2011 and reversed, holding that the state law tort claims were not preempted by the federal motor vehicle safety standards regarding inner-rear seat belts. That case was Williamson v. Mazda Motor. After remand, a new trial court judge noted that in light of discovery, it now appeared there would be a substantial defense raised regarding misuse of the inner-rear seat belts, causation, and comparative fault, and the trial would include testimony from non-party fact witnesses located in Utah. In light of these facts, the trial court stayed the action pending filing of a new action in Utah. The 4th District affirmed. It concluded that under Section 410.30 of the Code of Civil Procedure, a trial court has power on its own motion to stay or dismiss an action on forum nonconvenience grounds, and that authority does not require any heightened standard for reconsideration of the issue. As the court explained, facts developed during discovery may well affect the merits of a decision on the convenience of the forum, and the trial court should have the freedom to reconsider the forum's convenience in light of those new considerations. And that's it for today's Kelso Report. Have a great day in the law.